Welcome all, my dear friends. Today we are starting a new series that will be based on some case studies. Okay, so today we will start with our case study number 1. Fine. Beautiful, na? Okay, let us proceed. And we will start with case study number 1, that is about BAJAJ Auto Limited versus TVS Motor Company Limited JT. Okay, so we know friends, these two companies are very renowned companies. So we must have heard about BAJAJ Auto Limited, and we also very well we know about TVS Motor Company. So let us proceed with what is the case about. Why there is a conflict between these two companies. Fine. So let us proceed. Now, what are the aspects? This case has two aspects. One related to patent infringement and the other related to the speedy disposal of intellectual property rights cases. Fine. Next point is the case involved the unauthorized application and use of the patented digital twin spark ignition, that is in brief we can say DTSI technology by TVS Motor Company, which is the defendant. Okay, TVS Motor Company here is the defendant and BAJAJ Auto Limited is the plaintiff. Okay, so the DTSI was the intellectual property of BAJAJ Auto Limited, who is the plaintiff. Plaintiff had applied for a patent application for the technology in the year 2002 and was granted a patent in 2005. Okay, these are the some aspects of the two renowned companies. Fine. Okay. Now let us go into the facts. Okay. In 2007, plaintiff filed a case before the Madras High Court against the defendant for infringement of the patent and sought a permanent injunction for the same under section 108 of the Act. That means the Patents Act. So before proceeding friends, let me tell you one thing. In the note you can see what is the definition of a plaintiff and what is the definition of a defendant. Okay, so the person or entity that files the lawsuit is called the plaintiff, and the person or entity being sued is called the defendant. Fine. So here let us go to the reach to the point number 2. Okay, so the point number 2 says the plaintiff also filed for a temporary injunction while the suit for permanent injunction was pending in the High Court. Okay, so for reference, section 108 is section 108 of the Patents Act 1970 is reliefs in suit for infringement. So better you can refer this section. Okay, okay, let us proceed. Let us proceed with some more facts. Okay. Simultaneously, a second suit was filed by the defendant under section 106, claiming that the infringement claim filed by the plaintiff was baseless as they had made improvements and changes to the patented article. Fine. That means the plaintiff filed under section 108 and the defendant filed under section 106. Fine. And we can say for reference we can see what is section 106 about. This is power of court to grant relief in cases of groundless threats of infringement proceedings. Okay, so that means the plaintiff argued on its behalf and the defendant argued on its behalf. Okay, so please remember these two particular sections, that is section 108 and section 106 of the Patents Act 1970. Fine, let us proceed. Now we will proceed with some more facts. Okay, the High Court granted the plaintiff a temporary injunction and instructed the defendant that they could execute pending orders but could not take any new order for vehicles using this technology. That means that DTSI technology. If there are some pending orders, they can execute for that. But if there are some new orders, they should not use that technology. Okay. The next point is, however, the injunction was vacated after a plea from the defendant which led plaintiff to file an appeal before the Supreme Court of India. Okay, as the injunction was vacated after some time, then the defendant, then what did the plaintiff do? The plaintiff filed an appeal before the Supreme Court of India. Fine. Okay. Now, what are the issues? Whether defendant had actually infringed the patent even though it had in fact made improvements and changes to the patented article. Okay, the question is whether the defendant had actually infringed the patent even though it had in fact made improvements and changes to the patented article. Fine, this is the issue. Now, appeal to the Supreme Court. So, what is the appeal about? However, the first point is, however, the Supreme Court did not look at the merits of the case. Okay. The next point is, for the Supreme Court, the main issue was that the legal battle had taken approximately 2 years over a temporary injunction. Okay. So, the Supreme Court concentrated on the legal battle that had taken approximately 2 years over a temporary injunction. The next point is, without looking at the merits of the case, the Supreme Court dismissed the appeal by stating that all matters in relation with IPR infringements must be expeditiously decided by the trial courts, especially at the point of granting or refusing injunctions. Okay, so the Supreme Court dismissed the appeal. Fine. And the next point is, the Supreme Court further directed the Madras High Court to hear the case on a daily basis and dispose of on or before 30th November 2009. Fine. So, these are the outcomes of the appeal to the Supreme. So, what was the final judgment? Okay. The final judgment for the patent infringement. Point number 1. The Madras High Court ultimately held that plaintiff has the patent on the DTSI technology and has been using it for 5 years. Okay. The next point is, the High Court used the doctrine of equivalence and stated that it is also clear as per the decisions, for the purpose of deciding the novel features to constitute pith and marrow, a purposive construction has to be given in order to make it essential requirement of the invention that any variant would follow outside the monopoly even if it could not have material effect upon the working of the invention. Okay, so here friends, we can say that the doctrine of equivalence is a legal rule in patent law whereby a party can be liable for infringement even though the party does not literally or precisely infringe every limitation of a patent claim. Fine. Also, about the pith and marrow approach, we can say the doctrine of pith and marrow is the doctrine that has been applied in English patent law for over a century to see whether there was an infringement of a patent where the product or process or device or apparatus alleged to constitute an infringement did not exactly or precisely fall within the text of the relevant claim within the specification of a patented invention. Okay. So, with this slide, friends, all the whereabouts of the particular case is completed. So, please go through each and every slide of this case study. If you are getting stuck anywhere, please write down to me in my comment box. Okay, friends? I hope it is pretty clear now. Happy learning, friends. So, friends, enrich your brain cell with proper food and proper knowledge. So, thank you all, my dear friends, for listening to me and watching my video. Please like, share, and subscribe my channel. Please keep questioning, please keep learning and keep enjoying. Thank you so much. God bless you. Jai Hind.